We are prejudiced from this. It's a late disclosure. The documents they gave him were documents they'd had in their possession for 4.5 years. It's definitely intentional, and it's substantial. He's an expert.
I don't know. I was just asking a question about the motion that was supposed to be filed last week. So what are you all asking me to do?
The motion in limine on the swastika. The notice we had yesterday and that other motion that at 3:30 we got this motion yesterday afternoon, motion on the fire station rebuttal. And in that email, defense said that they wanted to hear it Tuesday. So that was, since it wasn't filed yet, I wasn't expecting it was going to be heard today.
Okay, so rather than sit here and just go back and forth on when things were filed and who can be ready for what, would it be more prudent to just have these heard tomorrow, even though we're all here?
I'm ready to run. The court wants to do the one today or all tomorrow. It's the court's pleasure.
Okay, so we have three motions. We have I'll call it the swastika motion, which I'm very familiar with. I assume both sides are familiar with that motion and the merits of it because it's been argued many times. And who's going to be the point person from the defense?
I will be on.
All right, are you ready to argue that motion?
Yes.
And state you're ready to argue D306?
Yes.
I'm sorry, not D306, excuse me. SF222 in response to D306.
Correct.
Okay, is there anything that you'd like to add to your written motion?
No.
There's no argument?
Oh, and yes, there's oral argument. Yeah, I thought you meant in addition to what I
No, anything at all that you would like to add? In other words, any additional argument, case law, anything that you would like to add, you may do so now.
Okay. Thank you very much.
Sure.
I do want to, I'm sure the court has seen the defense exhibit. They filed a timeline of the history of this motion, which was originally filed back in January of 2021. The motion was originally for the admissibility of hand-etched swastikas on the defendant's boot that he was arrested with after fleeing the scene, and also recovered on the AR-15 magazine. The motion has since evolved and now includes hate speech that was discovered and contained in the defendant's social media. When the original motion was filed, obviously the defendant had not pled yet, and the basis for that motion for the state's purposes was identity. Once the defendant fled in October of 21, that issue obviously was evaporated, identity no longer an issue. However, the state maintained the filing and wanted the court to rule on it in the future if it became relevant to the state in the penalty proceeding. And that would obviously be dictated by whatever the defense mitigation was during their presentation. So we've now reached that point where the defense has put on their mitigation, we're ready for rebuttal. It is at this point that the state would argue the motion is right. The defense has been complaining that the state did bring up the motion and they didn't get a ruling, so they couldn't question during jury selection issues about hate speech or swastikas. They had no problem asking about animal abuse. They had no problem asking about white privilege. They knew what records that they were going to be admitting. We did not. They admitted records from the school board, which is Defense Exhibit 92, and records were introduced in Perry Yard, and that is Defense Exhibit 78. Both of those documents contain language about the backpack that this defendant wore with the swastika drawn on it, and also the phrase F-N-words. Again, we didn't know who was being called or what evidence was being admitted, as this court saw maybe the night before, sometimes the morning of. So the defense knew what records they were admitting. They made the strategic decision not to question the jury about swastikas or hate speech. They cannot now come to this court and complain or blame the state when they were in control of the evidence that they were going to admit. They had the opportunity to pick and choose their evidence the same way they have an opportunity to pick and choose what to talk to the jury about. So now, based on the fact that those records are in evidence and that documentation regarding the swastika and the racial slurs there, any prejudice has now evaporated. And it's in evidence. And there were plenty of records. They didn't have to admit those records. They could have chose bits and pieces, but they didn't. They put them in evidence. They've opened the door, and now the state is going to march through. The photo of the backpack is what the state is seeking to admit. It is a photo of the defendant wearing the backpack, and you can clearly see the language that's written on it and the swastika that's drawn on it. It is to admit in the state's case a rebuttal to show he's not a victim of bullying, that anyone who walks around with that kind of language and symbols on a backpack is clearly provoking, and which also lends itself to the diagnosis of the state's experts, which is antisocial personality disorder. And since the state plans on putting on testimony regarding that, and that is also to rebut the defense experts' diagnosis of neurodevelopmental disorder related to prenatal alcohol exposure, along with alcohol-related neurodevelopment disorder by the defense. I'm sure this court recalls Dr. Brandon's lengthy testimony on July 7th, and he testified that social media searched by this defendant that covers racism, animal abuse, hatred towards women, Hitler, porn, Black Lives Matter, is all important to this diagnosis because it is a window into the defendant's mindset and hatred towards others, which is a critical piece in making that diagnosis. And for some reason, the defense keeps isolating words like Holocaust, Nazism, and Hitler, and argues because those terms don't lend themselves to any diagnostic criteria with antisocial personality disorder, they shouldn't commit. This is the totality of the search. The defense doesn't get to pick and choose what experts use in order to come to their diagnosis. This court heard that very, very long list of terms that Dr. Brandon read into the record. This wasn't the defendant doing research for a history project. This was clearly displaying his contempt for people, his hatred for people, his disregard for the rights of others, aggression, so on and so forth. All the checklists that goes towards diagnosing antisocial personality disorder. It's a multifaceted defense, and again, the defense doesn't get to dictate what social media the state's experts can and cannot use to make their diagnosis. They are not the psychologists, they are not the psychiatrists, they are not the experts. So again, the defense has opened the door by admitting the records, the documentation of the swastika and the racial slurs, and then for that reason, they cannot now claim prejudice. The state should now be permitted to admit the photograph of the defendant wearing the backpack with those items on it, the boot that he wore, photographs of the boot he wore on the day of the shooting, and the etched swastika that's on the AR-15. The state has as in social media, obviously the state has a right to rebut any defense mitigation. Both defense experts testified as to the diagnosis of NDPAE and the ARND. The state's rebuttal is that the defendant should be diagnosed with antisocial personality disorder. That hate speech contained in the searches by this defendant is relevant and certainly part of the expert's overall diagnosis. So, Your Honor, for those reasons, everything that's in the state's motion 222, we incorporate all the other arguments that this court has heard, and I know it's very familiar. We would ask that we grant the state's motion for admission of all those items. Thank you.
Defense?
Good afternoon, Your Honor. The defense has had opportunity to review the state's motion at step 222. Your Honor, and it's our position that the defense has not in fact opened any door. On September 1st of 2022, the defense called witness Carrie on. There was some documentation that she had maintained control and possession of since Mr. Cruz was no longer a student at the school for fear that the school board would have destroyed it, so she kept it. She turned that over to the defense during her deposition, and we wanted that documentation to be admitted during her testimony. We spoke with the state and asked that the swastikas be redacted from that document. They were in disagreement with that, and we had arguments as to that. We asked the court to redact the swastikas in light of the fact that we had not received a pretrial ruling on SF 202. I then went through the procedural history of that motion. I don't want to do that again, so I'm asking if the court will accept the arguments and the timeline that I provided on September 1st of 2022. Over the objection of the defense, the court allowed the state, indicated that the defense would have to submit all of the documentation with all of the information, specifically the swastikas that we asked to be redacted. So it was admitted. It was admitted after we had requested that that information be redacted, and without the court giving the defense the benefit of a pretrial ruling like we had requested before the jury was seated, before General Gordire was taken. Briefly, Judge, even if the court is going to continue to expand the ruling that you made on September 1st of 2022, this court still has the discretion to admit evidence and to limit evidence, especially if it's prejudicial, overly prejudicial, or cumulative. This is a thinly veiled attempt by the state of Florida to introduce bad character evidence. They want to get up there and say, did you see this social media post? Did you see this? Did you say that? Dr. Brandon testified that this information was necessary because, meaning the social media, because it showed a persuasive pattern of disregard for the rights of human beings. What the state did not elicit from that witness was that Mr. Cruz had searched had done 8,700 searches, and only 430 of them contained the content that the state is seeking to admit. So it's not a persuasive pattern. Perhaps that's an argument that we need to make on cross-examination, that the court does need to take into consideration, since you, in essence, have already granted SF 202 on September 1st over the objection of the defense, that information can be cumulative and it can be overly prejudicial, and the state will be trying to make this a feature of the trial. Had the court ruled on this motion prior to jury selection, we would have voir dire on those particular issues. So in light of the fact that the defense was unable to voir dire on those issues, despite numerous requests to have the court rule on the state's pretrial motion, and it also would have impacted the presentation of our mitigation in this phase. The court, that we would also say that if the court is inclined to allow the state to get into this material, a door which we did not open, the door was opened by the court by allowing Ms. Carry-on's documentation in over the defense of the objection, over the objection of the defense. The court still has discretion to fashion an equitable remedy and to limit the amount of this information that is moved into evidence. If the court is inclined to grant the state's motion, SF 222, based on the fact that the defense did not have an opportunity to voir dire on these specific issues because the court had not ruled, we would also be moving for a mistrial. And I would just adopt all previous arguments, Your Honor, that related to this particular issue, specifically what was argued on September 1st, 2022.
I'm sorry, I missed the last part. You're moving for a mistrial for what?
Well, if the court is going to be inclined to grant SF 222, which is the state's motion to allow in the swastika, the hate speech, all of that information, this is a similar motion that the state had filed before Mr. Cruz had pled, and then had renewed it after Mr. Cruz had pled, and the defense had requested numerous times for a ruling on this motion so that we could fashion our voir dire and how we would anticipate presenting our mitigation. It would be impacted by this court's ruling. So if the court is inclined to grant this motion over the defense objection, we would be, again, like we did on September 1st, 2022, we're requesting this court grant a mistrial because the defense has directly been prejudiced by its inability, because of the court's failure to rule on this motion, to voir dire the jury members on these particular issues.
So, I'm sorry, I just make a quick distinction.
Sure.
Ms. McNeil is referencing records that were moved in by Ms. Young, which is the Defense Exhibit 78. They did not reference Defense Exhibit 92, which is from the school board, which has clearly written in there on threat assessment about the backpack. So that door has been open.
But state, just so that I'm clear, the additional arguments you're making, in other words, you're not substituting these arguments for the arguments previously made, that these things, I'll call them things, like the swastika and the language and the searches and those things, your previous argument were that those things are probative of the diagnosis of antisocial personality disorder. You're merely substituting your argument saying, or not substituting, but supplementing your argument now saying, not only are those things true, but also the defense opened the door and that these items were contained within evidence that was put forth by the defense in their case.
That's correct.
You're not substituting an argument, you're supplementing.
Adding to.
That evidence that the defense sought to admit was the documentation from Carry On. We had requested that the court redact the prejudicial information that was contained within those documents, and the court denied that request. So the court essentially allowed that information in evidence, so the defense was in a position where they either hide evidence from the jury or we give them a complete picture. We had no other choice because we need to be honest with this jury so that they have all the information they need in order to make a decision. The remainder of the school board records were in fact admitted.
Okay, first of all, I didn't keep anything out of the school board records. I specifically asked you all what you wanted out of the school board records, and you didn't know. The state was the one that had to tell you that those prejudicial items were within the school board records. So how could I possibly know what was in them if you all didn't even know it was in them? And you were going to take the time to try to go through it at a later time, and you wanted me to admit them with the caveat that you'd be able to go through and figure out which items you thought were prejudicial, and then you never brought it up again. So I don't know how you could be blaming that on me when I don't know what was in them. You had 5 boxes of records. When I asked you all what portions of those records you wanted out, you didn't know.
So Judge, after the court had ruled on the documentation, the composite for Carry On, which allowed in the swastikas, the defense was in a position to make a decision about whether or not we should move in all of the evidence because we didn't want the jury to believe that we had misled them. So when the court allowed the swastikas to be admitted in through Carry On over the objection of the defense and denying our request to have that particular information redacted, we made the decision that we had to admit everything because of the position that we had been placed in. And the court still is required to make a 403 analysis on the additional information that the state intends to see admission of. So we would ask that the court exercise your discretion and apply that 403 balancing test.
Judge, I just point out that this was a strategic decision by the defense to admit all of those records. Nobody made them, the court didn't make them, they decided to put them all in, they opened the door, and now the state can go through it.
I'm going to have a written order by tomorrow.
Judges, if there's any way, if the court is in contemplation of granting the state's motion, that they could specifically allow us or advise the court as to what they tend to admit so the court can make a determination if you in fact do need to limit the amount of it so that it's not cumulative or overly prejudicial.
I don't know what you're asking. You want me to order the state to tell you in advance what they're going to put in the rebuttal case?
No, specifically the items that they refer to in their 222. Is that the court is going to exercise your discretion to try and limit the amount of that information so that it's not cumulative, so that it's not overly prejudicial. The court doesn't have any way or ability to make that determination, so we would ask that the state advise the court and the defense what information they intend to introduce that supports what they have in SF 222.
Okay, well, their wherefore clause on page 5 sets forth exactly, and I'm assuming that you're not asking to put any more or any less than what's indicated in your motion, which says firearm magazine hand etched with swastikas on each side of the magazine, loaded in the AR-15 firearm used in the shooting and left at the scene. 2, the boots worn by the defendant when he was arrested approximately 1 hour and 20 minutes after the shooting began, which has a hand-etched swastika on the right boot. 3, the photograph of the defendant's red backpack depicting a swastika and racial slur. And 4, hate speech contained in the defendant's social media.
So thanks for the clarification on that, Judge. I think that my argument needs to be more specific as to number 4, which is the hate speech contained within the defendant's social media. There's over 400 potential searches that the state could be relying on. So we would just ask that the court seek some direction from the state so that you can make, you can exercise your discretion to make a determination if it's going to be cumulative, overly prejudicial. The court has the ability to limit evidence. It's within your discretion to do that. Thank you.
Do you have any idea of whether you intend to use all, some, or? Sure. And you can let me know at a later time also.
Your Honor,
Yes.
we will provide a list at this time. We just would, I would tell the court it's not to be a feature of the trial, but as far as there's a timeline progression, and, we want to make sure people, what is relevant and, it's relevant to whoever's testifying, so we provide it to the court, to the defense, but I can't do it right now,
Okay, when can you have that prepared?
in the next couple of days.
Okay. Now, as far as these other 2 motions are concerned, obviously I would like to hear them before next week.
Judge, we would ask if we can come back tomorrow because the court's ruling on DMIL 16, if the court is inclined to limit the state to certain experts, then, otherwise we'll be preparing motions in limine on experts that may never be testifying and would be asking for additional hearing time to hear those motions in limine. So it's sort of in other words, it's like one depends on the other, it's a progression. So once we know the court's ruling on DMIL 16, then we'll know which of these experts we need to file motions in limine regarding the decision.
State, I don't mean to put you on the spot, but if I give you like 30 minutes to look this over, can we do it this afternoon, or do you need do you need me to reset it? I am putting you on the spot. It's not my intention, but
It's 3 o'clock. Okay, or-
sure, today? I mean, I assumed we were gonna be here all afternoon, so that's fine with me. I appreciate that, and if there's anything else, you all can get together before 3 o'clock. We'll recess till 3, and then we'll come back and I'll hear these, okay? All right, thank you. Foreman is present. Are you all missing somebody from your side?
Mr. Seaport's not going to, but we can go forward.
Dave, have you had enough time to review the two defense motions?
Yes, Your Honor, thank you.
Sure. Defense, I'll just go in order. We'll start with the motion to strike state witness, D 334, who's going to be arguing on this one.
Hi.
Whenever you're ready.
I don't mind if they're related, so I don't mind if we just argue together.
Okay.
Okay.
What was the last thing you said?
I said I intend to argue both of them together because they're related.
Okay.
If the defense would like to do the same, that's fine.
Whenever you're ready.
Okay. Judge, I'm not going to take up too much time because most of this is all spelled out in these motions. The motion in limine to require the state's rebuttal to address mitigating circumstances presented and to limit cumulative rebuttal evidence, there's sort of two aspects to that. One is that rebuttal is just that. Rebuttal is evidence that proves or shows up that what the opposing side said is not true. And now, in a capital case, the state's rebuttal can also argue for the diminished weight of mitigating circumstances, but the rebuttal case is not an opportunity for the state to simply present evidence of Mr. Cruz's bad character, and it's not an opportunity for the state to present evidence in aggravation that it chose not to present during its aggravation case so that it could present it after the defense has had their opportunity to speak. The rebuttal has to address mitigating circumstances raised by the defense. And I list on pages 2 and 3 the mitigating circumstances that were presented. Most of these came from our Rule 3202 notice, not all of them. And then going to the experts, and this, the court remembers the litigation that we have with regard to the number of state experts that could evaluate Mr. Cruz. The defense called at trial a speech and language pathologist, Dr. Shamika Stanford, a pharmacologist, toxicologist, Dr. Susan Scully-Danziger, Dr. Paul Connor, a neuropsychologist, and Dr. Kenneth Lyne Jones, who is a medical doctor, albeit an expert in fetal alcohol spectrum disorders. The state has listed and is presumably intending to call, although we don't know this, we just haven't heard anything to the contrary. They have two neuropsychologists, 3 forensic psychologists. One of those is the same person. In other words, one is a neuropsychologist and a forensic psychologist, a psychiatrist, and then a psychologist. With a couple of exceptions, and we're not entirely clear on Dr. Gilmet. He is actually, I think, set to be posed again tomorrow. His referral question initially was to rebut any claim of intellectual disability, which was not raised as a mitigating circumstance. So whether he has anything else to say or not, we don't know at the moment. But, and then Dr. Ferguson, which we'll talk about in just a moment. The rest of the doctors, Dr. Denny, Dr. Scott, Dr. Zapp, Dr. Brandon, all have arrived at the exact same conclusion, that Mr. Cruz has antisocial personality disorder, borderline personality disorder, and is malingering with regard to certain symptoms. So irrespective of whether any or all of their testimony does in fact rebut a mitigating circumstance, certainly to have 4 doctors come in to testify to the exact same thing would be unnecessarily cumulative, and under Rule 403, the court can limit that. We did not call a psychiatrist, so with respect to Dr. Scott, although he is admittedly the only medical doctor that the state has listed, so if he wants to try to rebut medical testimony, that's understandable because he's the only one that could. But to have 3 forensic psychologists all testify to the same thing is unnecessarily cumulative. So we're asking that the court limit limit the state's rebuttal so that it's not cumulative and that it actually rebuts. And I understand that it's going to be a little difficult here now to decide what is rebuttal and what isn't, and who should testify and who shouldn't. But at the very least, we need to allow the state to have psychologist after psychologist after psychologist come in to all say the same thing. Would be unnecessarily cumulative, and it would, frankly, just waste everyone's time. So we're asking that the court limit. With respect to Dr. Ferguson, we have a couple of issues with respect to him. And I'll address the motion to strike before I come back to our arguments on his rebuttal. So on September 9th, 2022, that was not this past Friday, the Friday before, 2 weeks into the defense mitigation case, the state listed this witness, Dr. Christopher Ferguson. They gave us a list of the materials that he reviewed. What he reviewed basically are these psychological evaluations that were done on Mr. Cruz throughout his time at the Broward County School. So these are documents. These evaluations have been in the state's possession since at least May of 2018, because that's when they were turned over to the defense. They gave him materials to review that they've had 4.5 years, and if they wanted him to rebut something as a result of that, then they could have listed him years ago, or at least when they listed their other experts. He is an expert witness. He's not a records custodian. He's not just a fact witness. He will be able to render an opinion, so it is a substantial discovery violation for them to give us this after we have already, not just after the trial started, but after 2 weeks into our mitigation presentation. Additionally, Judge, the prejudice is, there's a few things. One, we may have done something slightly different in our mitigation presentation had we known this witness was going to testify and had known what he would testify about. Also, Judge, depending on what he tells us in his deposition, we don't know whether we'll have enough time to prepare an effective cross-examination. They could theoretically call him first on Tuesday morning, and we may not be ready on that. And third, because they won't make him available to us until this coming Friday for deposition, that leaves absolutely no business day in between our deposition of this witness and the commencement of the rebuttal case, which means that there is no time for us to litigate any issues regarding the relevancy or prejudicial nature of his testimony. All we can glean from this witness's experience is that he may be testifying about a connection between playing violent video games and committing violent acts. That was never raised in mitigation. So we have absolutely no idea what this witness would testify about, and by the time we find out, it's going to be the last business day before their rebuttal case. So we're asking that the court strike this witness as a discovery violation, and if the court is not inclined to do that, the court can fashion another remedy, which would be to either make the state produce him sometime earlier this week for deposition, or the court can set aside time on Tuesday or an order that the state not call him prior to giving us an opportunity to litigate the issues with respect to his testimony. And again, as I said, if he is going to testify that the research does not support any connection between playing violent video games and committing violent acts, that was not ever raised as a mitigator. It's never been argued by the defense. No expert witness on the defense testified to that, and so it would not be relevant mitigator rebuttal. Thank you.
Thank you. State?
Your Honor, I'll begin with Dr. Ferguson. First of all, the defense, so there's a motion to strike state witness D-334, but in their motion in limine D-MIL 14, they speak of Dr. Ferguson, and I just want to...
You said DMIL 14. Do you mean 16? Or do I need to?
Did it change?
The copy that I sent you was wrong.
Oh.
The one I sent you yesterday.
Oh, I copied, the one they sent yesterday said 14, so I guess it's 16.
But
Everything else is.
It's the same
Everything
motion, I don't
else
need
is
to
the
pull,
same.
but, okay, I just wanted to make sure I'm on the same document that you're talking
You
about.
say 16? I didn't know what, okay, thank you. So in DMIL 16, the defense in paragraph 16 addresses Dr. Ferguson. And he indeed is an expert in violent video games, social media, and the commission of acts of violence. And the defense says in this motion, it's a little bit different than what they argued in their motion to strike, is that the testimony regarding Mr. Cruz playing violent video games pertained to his unhealthy obsession with playing video games and his inappropriate responses to being prevented from playing them or for losing at his video games. Contrary to what's been argued by the defense, what has been presented, it repeatedly began to come up in the defense case about violent video games. Mr. Gold on August 31st testified they seem to play a lot of violent video games, and that's at page 7548 of the record, line 4. He, on 7557, strike that, that was about Zachary coming over to playing violent video games with Rocky. Mr. Vesey on 9/1 was asked a question, and the record site is 7863. On line 18, the question asked was, did you know about his obsession with video games? And the answer was, through his mom and through our support staff meetings. And then the answer goes on, but it doesn't address until at the end of it about him punching holes in the walls at the home because he would get frustrated with the video games and things of that nature. And then the same day, Ms. Carrie Yon, she, from the teacher from West Glades, who appeared, as you might recall, on Zoom, and I think she was in her husband's office, I think in Palm Beach at the time. She testified at page 7786 on lines 3, reading from a record that she had produced. The defense had to read this into the record. I quote, I do not feel that he understands the difference between his violent video games and reality. So the defense, contrary to their argument today, has clearly put his obsession with violent video games into evidence as interfering with his ability to tell the difference between reality and the games themselves. In their motion via MIL 16, they say the evidence came in pertained to his unhealthy obsession. So clearly, that could be a mitigating circumstance, that he had an unhealthy obsession with violent video games. It's clearly a mitigating circumstance. So all of this was August 31st or September 1st of this year. Our records, I'm told that we actually, not that a day matters, but I believe we listed Dr. Ferguson on September 8th, 7 days. The defense says 8 days. I'm sure that doesn't matter. The state has, it's not that we're preventing him from testifying. He has a busy schedule, and there was negotiations, and there was emails exchanged between the defense and the state and Dr. Ferguson, and that was the first time that he was available was the Friday. We have no objection to not putting him on the first day of our presentation so that they have that extra workday if they deem it necessary. But a motion to strike a witness, it's really, they're asking for a Richardson hearing. It's premature. They're going to depose him, so they'll have an opportunity to depose him. The defense, the state has listed him, so, and the argument about the psychological records, that it never had come up before that the defense was going to use violent video games as an unhealthy obsession by their own admission as a mitigating circumstance, or that he can't tell the difference from reality and a violent or a game itself. So it clearly came up during the trial. The psychological records that were given to him were just so that he knows what the defendant was diagnosed with as a child. These are psychological records from the school, so it's just a record so he knows what he was diagnosed. As to whether or not that'll make a difference as to his opinion, the state anticipates that his opinion is that there is no causal relationship between violent video games and killing. And that will be about the extent of his testimony, which the defense will have ample opportunity to take his deposition. So if I can move on now to the rest of their motion, on their motion in limine, I'd like to point out, first of all, the defense has just told you that the list of mitigating circumstances that they intend to use that's contained in this motion is not exhaustive. So the state still has to guess as to what the mitigating circumstances might be. But what they have provided to us in this list, and I just want to highlight some of them, because they go to his mental health defense, such as has neurodevelopmental disorder associated with prenatal alcohol exposure. Now, as their witnesses, their experts testified, that was a DSM diagnosis. Somehow the defense argument is that all we can do in rebuttal is have a witness say, no, that's not the diagnosis. Clearly, that's not an accurate statement of the law. They don't cite any cases that say that. They have put the defendant's mental health in dispute. It is an issue. The state can then present different diagnosis under the DSM, which the state intends to do as to antisocial personality, borderline personality, and that he malingers. I'd also like to point out that the defense also listed impaired social skills, memory deficits, motor function delays, impaired motor skills, neurological impairments, multiple deficits in adaptive functioning, brain damage, executive functioning deficits, independent functioning deficits, cognitive deficits, intellectual deficits, central nervous system abnormalities, developmentally delayed and diagnosed with ADHD and OCD. Now, the defense puts in this list intellectual deficits, and then in paragraph 14, they say the defense did not claim either in its notice, 3.202 notice, or its actual mitigation presentation that Mr. Cruz is intellectually disabled. Now, they claim that he has an intellectual deficit. Now, whether it's deficit or disabled, the state is able to rebut that. The state is able to present rebuttal testimony. This argument should be immediately dismissed. Excuse me just a moment. If you recall, Dr. Jones, the defense expert, pediatrician, testified that FASD, fetal alcohol syndrome, caused the murders, which was a very open-ended conclusion that he made. The defense in footnote 2 states that they did not present evidence regarding 3 mitigating circumstances, which include: 1, the defendant was under the influence of extreme mental or emotional disturbance;
2, capacity to appreciate criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. And 3, the diagnosis of acute psychosis immediately after the incident. Accordingly, quoting the defense, any rebuttal of those mitigating circumstances would be improper. When the defense presents mitigating testimony that FASD caused the murders, it encompasses the defendant was under the influence of an extreme mental disturbance or emotional disturbance. That clearly is encompassed. The capacity to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. That's encompassed when you say FASD caused the murders. So whether those exact words are addressed, that still needs to be rebutted by the defense if we're able to. And the defense wants to hide the defendant's malingering. Again, the defense has put his mental state into issue in this case, and as the defense admitted in footnote 4, where they said, like any other rebuttal evidence, evidence of Mr. Cruz malingering must relate to him malingering regarding a condition that was raised as mitigation in the defense case in chief. So that's ridiculous. I mean, it's a ridiculous argument. So he's lying about one condition, but we can't bring that out to show that he's lying about testing with another condition. And the defendant doesn't say, okay, my lies are only directed to the ones that the state is interested and not the defense. It just doesn't make any sense whatsoever. And the defense admits that, and what they're concerned with is that his claim of hearing voices would be improper rebuttal because the defense did not present testimony or any way that he hears voices, in other words, psychosis. And quite frankly, they admit that their own expert is the one who's testified that that they do not believe he hears voices, and that he believes the voices are simply his own negative thoughts. How the defense could say, well, you can do malingering, but only if it relates to antisocial personality, not to something else. Clearly, he put his mental state in evidence. Everything would be fair game, whether or not we do it or not, whether or not we choose to enter that testimony. And that's my next argument, Your Honor. The defense can't just file a motion in limine and say, Judge, tell the state what witnesses they can call and what the witnesses can testify to. How on earth would the court do that, first of all? They have the ability to make objections during the trial as to cumulative evidence, whether or not it properly rebuts. It's not something that the court could possibly rule without hearing the testimony. I want to cite some cases to the court so that the court has some additional guidance. And I'd cite to the court Gutierrez versus Vargas. It is a Supreme Court of Florida case, 239 Southern 3rd, 615, a March 22nd, 2018 decision. And in this case, they cite a 4th District Court of Appeal decision. If the court would indulge me reading this section, I think it's very important. In Delgado, D-E-L-G-A-R-D-O, the 4th District Court of Appeal determined the testimony of one orthopedic surgeon was not cumulative to the testimony of a second orthopedic surgeon, both of whom had treated the plaintiff. And that's at 731 Southern 2nd at 11 and 12. The trial court had not entered a pretrial order limiting each side to one expert per specialty. Instead, the district court reviewed a trial court's order granting a new trial on the grounds that the testimony of the two surgeons was cumulative and repetitive. In holding that the testimony of the two surgeons was not cumulative, the Fourth District explained, while two proposed witnesses of the same medical specialty might indicate the possibility of cumulative evidence, the real question is whether they will testify to cumulative opinions based on the same facts. Clearly, a party is not necessarily guilty of calling duplicative witnesses simply because she calls two witnesses of the same medical specialty. The testimony of the second surgeon in this case establishes rather clearly that his evidence was based in part on the same facts and evidence as the first, but also in part on new facts and evidence. Therefore, as a matter of law, it was not cumulative. So we have the defense argument that, well, Dr. Scott, who is an eminent psychiatrist who examined the defendant, he has his examination of the defendant. Dr. Denny, a neuropsychologist, he examined the defendant, and he has his examination and his facts. They can rely on each other, but each has additional facts that they bring to their own examinations. It's just because he's a medical doctor as well doesn't mean he's limited to the FASD characteristics of the defendant's lip. I mean, that argument simply does not fly. And the court would have to listen to all the testimony before it can make its determination. The defense has somehow, and I anticipate they're going to say, well, Your Honor, you limited the state to two different doctors to examine the defendant, and therefore, I don't know, they're trying to make that argument in writing in their motion that somehow limits how many experts we can call to the stand. One does not matter to the other. How many experts could examine the defendant has absolutely nothing to do with how many experts can testify in the court, as long as it's not needlessly cumulative. I can just have one moment to make sure I've addressed all of their notes here.
Sure.
I did not, since they only have a calendar preparing on it, thank you. The same would go for the psychologist. The court could not make that decision until they heard from the psychologist. To the extent that this motion just restates about cumulative evidence, the state is aware of that. But rebuttal is not merely as the defense suggests. Your Honor, for all those reasons, the state would ask that both motions be denied. Thank you, Your Honor.
Thank you. All right, I'm going to take all of the matters that I heard today under advisement. I'll try to have an order by tomorrow. And Mr. Marcus, I just wanted to make sure, I got the site, but I don't know that I got the name. Is it Gutierrez versus Vargas,
Yes,
239 Southern 3rd 615?
yes, and then I quoted from that case Delgado at 731 Southern 2nd, 11 through 12, before DCA. That's at head note 15, if Your Honor.
Okay, thank you.
Judge, can I just briefly respond to
Sure.
things? Okay. With respect to the motion to strike Dr. Ferguson, there's a big difference between having a neighbor come in and talk about him playing violent video games, and a principal and a teacher who is not a psychologist, who's not an expert, who said in a record that the state has been in possession of for months and months, and yet didn't find it compelling to hire and list this witness, that I sometimes wondered if he knew the difference between violent video games and reality. There was no defense expert, and not even these other witnesses, who are simply lay witnesses that just observed that he watched violent video games. No defense expert said that this offense was in any way committed, but because he played violent video games. So that is not rebuttal to anything that the defense has said. And when I said a moment ago that this list may not be exhaustive, and Mr. Marcus's response is we have to guess, they don't have to guess. I said it was not exhaustive because this is based on our 3.202 notice and my recollection of what we presented during the trial. It's not that they have to guess, they were there. Everything has come out from the defense. The defense rested its case. There isn't going to be any more mitigation presented in the defendant's case. So they don't have to guess. It's just, I may not have included every single thing that came out in this motion. Judge, if the court is going to allow Dr. Ferguson to testify, then we're asking that the court order that they make him available sooner than Friday for deposition. And if not, we're asking that the court order that he not be permitted to testify until we are given a fair and full opportunity to litigate any necessary issues regarding his testimony. Thank you.
Thank you. Is there anything else for today?
No, nothing to say.
Good. I'll have those orders too as soon as I can get them done, and other than that, we're in recess. I'll see you all Tuesday at 9 o'clock.